Hello everyone. Am I audible now? Hello everyone. Come on guys, comment on the chat box. Am I audible or not? Okay. Where are the other people? Can someone tell me? Only one student is there or other people are there because I can see 4 people in the Yes. I can see 4 people attending the session but nobody is commenting. Can someone tell me where are the other people? I think yes. Everyone is watching match. So let's begin. I have to start the quiz with the people we have. No issues with that. Now you tell me who have prepared for the part 2 of CRPC today. We are going to revise the second part of CRPC today, starting from section 308 till the last section. Okay, start commenting, guys. I want every one of you to answer. Shall I begin with the quiz? Yes or no? Am I audible? I think I am. Guys, come on. Am I audible? Good evening. Good evening, Shaktija. Okay, so let's quickly begin. Welcome, Medha. Good evening. Good evening. Okay, let's quickly begin with the quiz. Who have prepared for the part 2 of CRPC? Please start commenting on the chat box. We will begin with the very first question, and that is the very easy question. The provision for anticipatory bail has been given under Section 439, 438, 389, or 437. Those who are new, let me tell you, you have to comment with the correct option as Medha has commented already. I'll be giving you 5 seconds for writing the correct answer. Yes, yes. It is section 438. Very good. Let's move ahead with the next question. A sentence of death by a lower court must be confirmed by the High Court, must be confirmed by the Supreme Court, must be confirmed by the President. Okay. Yes. Yes. Very good. Very good. All 6 students have answered correctly. Very good, Manish. Very good, Shaktija. Very good, Medha, George. Yes, it has to be confirmed by the High Court and it is mentioned under section 366. We'll have a lot of questions revolving around this particular topic. This is a topic which is important not only for prelims but also for mains. Even anticipatory bail is also important. But yeah, this one question is asked everywhere. Confirmation of death sentence in prelims also and in mains also. Anticipatory bail under 438 of the CRPC means a direction to release a person on bail as bail issued after a person arrested, a direction to release a person on bail issued even before a person is arrested or is in apprehension of arrest, a direction to release a person on bail from judicial custody, a direction to release a person on bail when he is in police custody after being arrested. Yes. Welcome Sushil in the comment box. Waiting for everyone else to answer. What do you mean by an anticipatory bail? Come on, Manish. Medha has also answered. Nico has also answered. Shaktija has also answered. Yes. Anticipatory bail means when there is an apprehension of getting arrested. Many politicians also, many big personalities, you have been, I think, listening this word quite often in the news that a person has filed anticipatory bail to protect himself from getting arrested. Yes, it is also called a pre-arrest bail. Very good, George. The inherent power under Section 482 can be exercised by Supreme Court, Court of Session, High Court, all of the above. Okay, okay. This was quite an easy one. Yes, so the correct answer is option number three. Can someone tell me under which section of CPC inherent powers are mentioned and who can exercise the inherent powers under CPC? There's a difference between CPC and CRPC. Please mention the section in the comment box. I'm asking about the Civil Procedure Code and who can exercise the powers, the inherent powers under CPC. Yes, it is 151. And who can exercise the powers under CPC? That also I want to know. Which of the following sections deals with irregularities which vitiates the proceedings? 460, 461, 462, and 468. Is it? Is it Supreme Court? Yes, it is any court under 151. So there is a difference between CPC and CRPC, and this is how you can remember. CRPC has a restrictive approach and CPC has a broader approach. Any court can exercise under 151. Yes. Which section deals with irregularities which vitiates proceedings? Yes, it is option number two, 461. 460 is Meda, which do not vitiate proceedings. Which vitiate proceedings are 461. So it is ulta. This is how I remembered when I was preparing कि ये उल्टा है. पहले आता है first it comes which do not vitiate proceedings. पहले negative है and then positive है. This is how I remembered the sequence of sections for 460 and 461, and this can help you remembering the sections. Yeah, so read the questions very carefully. When such questions are there, do not. Okay, let's move ahead with the next questions. How many total chapters and schedules are there in the Criminal Procedure Code? 25 chapters and 3 schedules, 37 chapters and 2 schedules, 37 chapters and 1 schedule, 36 chapters and 2 schedules. Do not open the Bare Acts. This is just a warm up before we begin with technical questions, just to analyze whether you have studied the Bare Act from cover to cover or not. Okay, let me also check because everyone is commenting three, and what I think is there are two schedules. Yes, there are not one schedule. The first schedule is famous. That is why we always remember one schedule. There are two schedules. The second schedule have form numbers. So the correct answer is two and not three. Chalo. Yeah, Manish was right. Only Manish was able to mark the question right. So guys, read the Bare Act from cover to cover. Remember this. This is a very simple question, and if you mark the question wrong, this can be a pain for your whole life कि अगर आपने ये question गलत किया तो. So the answer is 2. Okay, a magistrate to whom a complaint is made under 340 or 341 of CRPC shall deal with the same as if it were a complaint case, shall deal with the same as if it were a warrant trial case, Shall deal with the same as far as maybe as if it were instituted on a police report. Shall deal with the same as it if were a summons case. Come on, guys. A very bare centric question, but a minute one. I agree on that. Okay, Medha has answered. Anikwa has answered. George has answered. Shaktija has answered. Okay, so the correct answer is option number three. Yes, it is. Shaktija, do not do this. You always mark the answer in the first reading correct. It is on a police report, not as a complaint case. It is mentioned under section 343. The procedure of section 340 and 341 is mentioned under 343, and it is clearly mentioned that the same has to be dealt with as if the case is instituted on a police report. That means the whole investigation process and the whole chapter 12 will be applicable. Okay. Let's move ahead with the next question. A criminal court at conclusion of trial may order restoration of possession of immovable property to the person who has been disposed therefrom by use of criminal force or by criminal intimidation by the person convicted, the destruction of pornographic material in respect of which conviction was recorded. Both 1 and 2, neither 1 and 2. Come on, guys. No section is mentioned, I know, but this is also a very bare centric question. Medha is on fire. Medha, quite impressed with the level of preparation you have. George, Manish, Pritika, welcome, Pritika. Yes, the correct answer is option number three. Very good. Shaktija, please read the whole miscellaneous part again today. So, yes, this is mentioned under section. These are mentioned in two different sections. That is why I've put this question to confuse you guys, obviously. So, this is under section 452 and 455. So, the court has the power to even restore the property, the possession of the property, and destruction of the pornographic material in respect of which the conviction was recorded, no, not without the conviction. If someone is keeping such things even without the conviction, then and if the person was acquitted, then the destruction might not take place. Okay, let's move ahead with the next question then. The proceedings before a criminal court are vitiated if the presiding magistrate, who is not empowered by law to do so, issues search warrant erroneously but in good faith, holds inquest under section 176 of CRPC erroneously but in good faith, tries an offender summarily. What is 176? Let me know in the comment box what is section 176 of CRPC. Come on, guys. Tell me what is 176, Ikto, and then tell me which is the correct option here. By doing what the proceedings will be vitiated. Okay, only Pritika answered. Anikwa also answered. Please tell me the correct. Yes, it is 3. It is 3 only. Shaktija only answered correctly. Only section 461 clause M prescribes this. I used to remember, by this I had in my mind that whenever an offender is tried summarily, because summary trials have a separate chapter altogether starting from section 260. So I used to remember this, that whenever an offender is tried in a shorter way, like you cannot go for shortcuts, right, in life. So whenever you do the shortcut without being empowered, the trial will be vitiated. Always remember this. So this is an option number 3. Yes, it is inquiry by magistrate on cause of death. Very good, Manish. Very good, Medha. Very good, Shaktija. I'm impressed by the correct answer. Now let's move ahead with the next question. Anticipatory bail can be granted by the Sessions Court when the offense committed is bailable, when the accused has committed a non-bailable offense and has been arrested, when the accused has allegedly committed non-bailable offense and is yet to be arrested, when the first information report has not been registered. When it can be granted. Everyone answered it correctly except few. No, it is not when the first information report has not been registered. It is when a person has committed a non bailable offense and the person is yet to be arrested. This was one of the questions from DJ's 2080. Welcome, Honey, in the chat box and in the session also. Yes, so it is section 438, which mentions the details about anticipatory bail, and there's no sense if the person has committed a bailable offense where it is mandatory to give the bail, to seek bail before the person has arrested. So anticipatory bail is always available only against a non-bailable offense and not against a bailable offense. Always remember this. Committed is stated, ma'am, got me wrong. Yeah, so in such cases, that is why I always ask the students to read the question paper twice, like give the first reading and then give the second reading, mark the answers in your question paper only, and then treat the OMR sheet. This is not applicable for MP. MP is conducted through the online mode. So the people who are going for DJS, they have to treat the OMR sheet like a baby. So the next question is, which of the following statements is incorrect? Incorrect. A death sentence imposed by a sessions court is subject to confirmation by the High Court. A death sentence imposed by a session court can be confirmed by the High Court only when a bench consisting of two judges or more hears the case. No confirmation of a death sentence imposed by the sessions court can be made before the expiry of the period for preferring the appeal. The High Court cannot acquit the convict while considering the case for confirmation unless he prefers an appeal. Very easy, but a heavy one. That is the reason I'm not changing the slide. Come on, guys. Okay. George has answered. Shatija has answered. Medha, Pritika, Anikwa, Manish. This the language of option number 2 confuse everyone. Manish, please read the question carefully. Why option number 3 not correct? Before the expiry of period, like this topic is, guys, really important. In the second part of CRPC, the only topic which I found mains worthy, except bails and appeals, obviously, is this. So please read the whole. I think there are 5, 6 sections only. Read the whole sections again because there are very minute details in this particular topic. This is very easy, but a very minutely put in the Bear Act. No, the correct answer is option number 4 here, guys. The High Court cannot acquit the convict. The High Court has the power to acquit the convict even if he doesn't prefer an appeal. Why option number 3 you guys are stating, I'm not sure, because it is clearly mentioned that the High Court cannot confirm a death sentence if the time period for the preference of appeal has not elapsed. And option number 2 is also right, which is obviously mentioned 2 or more judges are required to hear the case. High Court has the power to even acquit the convict in such case. So option number 4 is the correct answer here. Please read the whole topic again, which is really important in the part 2 of CRPC. Anticipatory bail under Section 438 can be granted by a Metropolitan Magistrate, Court of Sessions, High Court, both 2 and 3. Hi Sonal, welcome in the video. Yes, yes, yes. Everyone has answer very correct. The correct answer is option number 4. Both the High Court and the Court of Sessions here can grant the anticipatory bail. Okay, the inherent powers under 482 can be exercised by. This is a repeat question, so let's skip this. The which of the following sections deals with irregularities which do not vitiates proceedings? 460, 461, 462, or 468? Do not. Everyone is correct here. Yes, it is option number 1. Under section 468 CRPC, limitation for an offence punishable with a term not exceeding 1 year is 6 months, 1 year, 2 years, 3 years. Only few people have answered it correctly. For my surprise, this is a really, really easy question and a direct question from section 468, which is equally important for prelims at least. So, not like this is a very straight section: 1 year, 1 year, 2 years, 6 months, and 2 years, and above 1 year to 3 years is 3 years. So, this is very straight. Yes, only Manish and Medha Shaktija answered correctly. It is 1 year. It is option number 2. And this has been a question asked in DJS 2006. The limitation for a criminal court to take cognizance of an offence punishable with imprisonment for a term not exceeding 2 years is 6 months, 1 year, 3 years, 3 months. Come on, guys, मैंने अभी बता दिया ये answer. So please mark this correctly. थोड़ा tricky है because this is not mentioned in the Where Act. 2 years is not mentioned. Yes. Everyone is answering it correctly. Yes, it is option number 3. For 2 years, it is also 3 years, and for 3 years, it is also 3 years. Exceeding 1 to 3, the limit from 1 to 3, the cap is 3 years. The liability of surety is under the surety bond, mutually exclusive of the liability of the accused under his personal bond, contingent on the liability of the accused under his personal bond, limited to the amount of the surety bond, both A and C. Yes, correct, George. Not exceeding 3 years. कोई मुझे बता सकता है for exceeding 3 years, what should be the limitation period for criminal cases? Okay. Again, some difference of opinions. The correct answer is option number 4, guys. Only Anikwa was able to answer it. So both the sections mention this clearly. Correct. Medha is correct here. There's no limitation. So both the sections separately mention this, that section 441 and section 444, that the liability of the surety is mutually exclusive and limited to the amount of the surety bond. So always read the sections combined. Like the section should not be read isolated. So then you will be able to answer. Yes, correct, Manish. No limitation. Let's move ahead with the next question. In computing the period of limitation, the time during which any person has been prosecuting with due diligence another prosecution in any court against the offender shall be excluded. The period during which an offender is absent from India shall be excluded. The period during which an offender is absconding or concealing himself is excluded, or all of the above. Okay. Yes. All the 4 options are correct here. And refer to section 470 for more clarity. No, all the 4 options are clear here. Guys, please read the whole miscellaneous chapter again. All of you who are answering it wrong. Very good, Pritika. Very good, Meedha. Very good, Sonal. All the four options are correct here. Period of limitation shall commence from the date of the offence generally, from the date of knowledge of the commission of the offence if not known earlier, from the date of establishment of the identity of the accused if not known at the time of the commission of the offence, or all of the above. Yes. All of you have answered it correctly. The correct answer is option number 4, and the relevant section is 469. This is also a directly based question from the Bear Act. Where a high court sentences an accused to death or confirms a death sentence, an ordinary copy, and just see the amount of questions I have put from this particular topic. अपील से अभी तक एक भी क्वेश्चन नहीं आया, बेल से अभी तक एक भी क्वेश्चन नहीं आया, and see how many questions have been asked from this particular topic. An ordinary copy and not a certified copy of judgment shall be given free of cost without any application being made. A certified copy shall be given to the accused on an application being made. A certified copy shall be given to the accused free of cost whether an application is made or not. An ordinary copy and not a certified copy of judgment shall be given to the accused free of cost when accused applies for such copy. Read this whole topic very minutely, guys. Starting from 366, I guess. Yes. All of you are correct here. It is option number 3. Only the certified copy has to be given and only on the application of the accused. Let's move ahead with the next question. Are you guys with me on the same page, all the 11 people? Give me a thumbs up, guys. Or are you busy watching the World Cup on your another screen? If that is the case, then also it's fine. Let me know the scores in the comment box. I am also really worried about the situation of this country when it comes to cricket. Please let me know the score, guys, on the comment box. No, not without application, only on the application. Not on the application. I'm sorry, not on. Even when the application is not made, the certified copy only has to be given, not on the application. Okay, let's move ahead with the next question then. In an appeal for enhancement of sentence, the appellate court can order the retrial of the accused by the competent court. Is it true or false? See, Delhi judiciary has this trend of asking the questions relating to true and false. और उसमें बहुत ज़्यादा माइंड डाइवर्ट हो जाता है. So always practice such questions. Okay, don't do both. Stay with me here. I am also staying with you guys. We'll see the scores after the quiz. Yes, it is true. Yes, so this is mentioned under 386 very clearly, powers of the appellate court, that if the appeal is for enhancement of sentence, the appellate court can order the accused to be tried again, only by the competent court. Let's move ahead with the next question. No court shall take cognizance of an offence after expiry of the period of limitation, which is 6 months if offence is punishable with fine only, 1 year if offence is punishable with imprisonment for a term not exceeding 1 year, 3 years if punishable with term exceeding 1 year, all of the above. Wow, George, you can multitask. Yes, this has been told, I think, from the very beginning of the session. I think you are not required to revise 468 again. I have made you revise 468 quite a few times now. Yes, the correct answer is option number 4. Everyone is on the same page, and I'm really happy about it. Who can commute the sentence? High Court, Judicial Magistrate First Class, Supreme Court, none of these. Please let me know in the comment box the difference between commute, remit, and suspension of the sentence. Wow, I am really impressed. This I've made thoda tricky just to confuse you guys, and almost everyone is answering this right. Yes, it is none of these. Only the appropriate government can commute the sentence. This is not a judicial power, but the executive power. Please mention in the comment box the difference between commute, suspension, lessen the sentence, reprieve means change the sentence. And what do you mean by suspension? There are three words: George, commute, remit, and suspension. Till the time I'm moving ahead with the next question. Under Section 389, Clause 3, the trial court can release an accused on bail after conviction, where the accused is sentenced with imprisonment for a term not exceeding 2 years and no fine is imposed, whether he's on bail or not. The accused is on bail for a non bailable offense and he is sentenced with imprisonment for a term not exceeding 3 years. The accused is on bail and the offense is bailable one and he is sentenced with imprisonment for a term not exceeding 3 years. The accused is on bail and he is sentenced with imprisonment for not exceeding 7 years and no fine is imposed. Correct. Okay. This is a tricky one, I guess. Yes, Medha. Anikwa, you're on fire. I am really impressed, touchwood, with your preparation because I've been in touch with you. The kind of preparation, the kind of improvement you are showing is really amazing. Yes, correct. Correct, Medha. Please read this question, the one displayed on your screens. This is a tricky one, I guess, straight from the Bear Act, but this is a little tricky one. Medha is also on fire. Medha has also shown a massive improvement. Manish to chalo hai hi. Manish, touchwood, I'm like really proud of the students we have, including Shaktija, George, Medha, every one of you. Yes, the correct answer is option number three here. The offense has to be a bailable one. This was a little minute. The offense has to be a bailable one, and the terms of imprisonment is 3 years, which is obviously very much taken away from the Bear Act only. But the offense should be a bailable one and not a non-bailable one. Okay, let's. I also hope that, Anika. Let's move ahead with the next question then. Which of the following statements is incorrect? A is accused of the theft of a certain article at a certain time and place. The charge need not set out the manner in which the theft was effected. A is accused of disobeying a direction of the law with intent to save B from punishment. The charge must set out the disobedience charge and the last infringed. The charge can be altered even after final arguments, but before the judgment is pronounced. A is accused of cheating B at a given time and place. The charge need not set out the manner in which A cheated B. Why did I keep this question also? This is not a part 2 question, but I kept it here deliberately. Reason was yesterday's quiz. I felt you guys need revision on charge. Chalo. Yes, the correct answer is option number four, which is an illustration mentioned in the section stating that manner of the charge. No, the correct answer is option number four. Option number two is correct. And whenever they are accused of cheating at a given time and place, the charge has to set out the manner, not for theft but for cheating. Yes, correct. Which of the following statement is not correct? On conviction and award of death sentence, the proceeding shall be submitted to the High Court for confirmation. In proceeding for confirmation of death sentence, the High Court cannot make further inquiry or take additional evidence except to decide confirmation or annulment of sentence. Confirmation of death sentence can be decided by two. Okay, this is repeated, but I'll just ask you once again because all of you answered it correctly, wrongly. On confirmation or reversal of the order of death sentence by the High Court shall send a duly sealed and attested copy of order to the Court of Session. No, this is not repeated. This has a little change. Theft requires when the time and place has to be stated. Whenever there is mentioned the two words are mentioned, then the okay, welcome Pratibha. Then you have to set out the manner. Yes, the correct answer is option number two. Very good. Manish, Anikwa, Medha, Pratibha, Shaktija, very good. Um, High Court has the right to make further inquiry, and this is a different section altogether. They can take additional evidence also, and can also ask to for the further inquiry. Cannot do it themselves and can get the inquiry done. This is mentioned under 367, and the topic starts from 366. Appeal under section 377 and 378 shall finally abate on the death of the appellant. True or false? Come on, guys. Answer this correctly. True or false? सब घूम गया. All of you have been confused by just one word. Okay. So only Pritika and George are correct. This is false. Guys, 377 and 378 है क्या? पहले तो मुझे ये बताओ. Very good, Anikwa. What are section 37? This is why this quiz is called DJS quiz. Because such questions are there in DJS which tests your concepts. See, 377 and 378 pay, there's no requirement of the death of the appellant. It abates only on the death of the accused, क्योंकि these two sections are relating to the acquittal appeal against the like by the state government and on the acquittal. So these two sections clearly it is mentioned under section 394 that on the death of the uh, accused only section 377 and 378 appeal will be abated. So this appellant word confused you. Yes. So this was false. Okay, let's move ahead with the next question. What is the result of subsequent convictions as stated under section 427 of CRPC? Generally, the subsequent sentence shall run concurrently with such previous sentence. Generally, the subsequent sentence shall be cancelled. Generally, the subsequent sentence shall be served later. None of the above. This is straight away from the Bear Act. Yes, the correct answer is option number one. It will always run concurrently. Can someone tell me the difference between concurrently and consecutively? And the section relevant in CRPC and IPC. A victim cannot file an appeal against any judgment passed by the court in which of the following cases: where the court imposes inadequate compensation, where the court convicts for a lesser offense, where the court acquits the accused, none of these. A victim cannot file an appeal. Very good, Medha. Very good. Very good, Anikwa. Come on, answer this question displayed on your screen. which of the following cases the victim cannot file an appeal? Only George was able to answer in time. So the correct answer is option number four. Yes, none of these it is. Shaktija, it is none of these. Medha is also correct. So all the three conditions are mentioned under section 372. The provision of section 372 very well mentions it, and I have made this mistake. I don't know, in one of the prelims exam I attempted for. So I'll always remember this, that lesser offense है ये, lesser punishment नहीं है. So always remember this, where the court convicts for a lesser punishment, in that case the victim cannot file an appeal. Yes, in that case, for a lesser punishment, the victim cannot file an appeal. Only for lesser offense, when the inadequate compensation is there, or when the court straight away acquits the accused. Only in such cases the victim can file the appeal. Okay, Pritika, please read appeal wala pura chapter again. Ashaktija also. Let's move ahead with the next question now. A complaint made under section 340 of CRPC shall be signed where the court making the complaint is a high court by such officer of the court as the court may appoint. In any other case, by the presiding officer of the court or by such officer of the court as the court may authorize in writing in this behalf. Either one or two, and two, none of the above. Come on, guys. Yes, it is option number three. Both the conditions are mentioned very clearly under section 340. Okay, concurrent and consecutively. Yes, Shaktija, yes. Yes, Manish, it is correct. Let's move ahead with the next question. The maximum permissible compensation awardable under section 3457 of the Code of Criminal Procedure is rupees 3 lakh, 30 lakhs, 40 lakhs, none of the above. 357. Anikwa has answered it. Shaktija has also answered it. Yes, it is option number four. It is on the discretion of the court. No amount is mentioned under 357. It is on the discretion of the court how much compensation has to be granted. Yes. The judgment of criminal court of original jurisdiction shall be pronounced in open court by which of the following? Reading out the whole of the judgment, delivering the whole of the judgment, reading out only the operative part of the judgment and explaining the substance of it in the language which is understood by the accused or his pleader, any of the above. कोई मुझे सेक्शन बता सकता है? This is quite easy. I just want to know the section here. Which is the relevant section here? किस section में ये लिखा हुआ है? Then I'll move ahead with the next slide. Medha has been able to answer. Medha, Bear Act तो नहीं खोली है ना? Yes, it is 353. George, you are on complete fire. Yes, it is 353. Very good. Very good, Pratibha. Very good. So the court can do any of the above, but only in the language which is understood by the accused or his pleader. It could have been changed that in the even if the language is not understood by the accused or his pleader, the court can read out the judgment. So you'll have to mark that incorrect. Who may make an order of compensation under the provision of CRPC? An appellate court exercising its power of revision, a high court exercising its power of revision, a court of session exercising its power of revision, all of the above. Very good, Medha, then. Very good. Who can make an order of compensation under the provision of CRPC? Yes, it is option number four. Revision powers has been given to appellate court, high court, or the court of session. So this was also can be applied by logic if you have read the provisions relating to revision. So yes. Section 433 of the CRPC gives the power to the government to commute the death sentence for any other punishment provided by the IPC. Whether it is true or false. True, false, partially true, none of the above. Come on, guys. Okay. Shaktira thinks this is false. Meda also thinks this is false, but this is true. Without the consent of the person, the appropriate government can sentence. See, appropriate नहीं है इसलिए false बोल रहे हो. I don't know why you guys are saying it false. हर question में it is not every question is twisted. This is a direct question from the Bear Act. Yes, correct, Manish. This is true. When the prisoner is to be confined in a jail to whom the warrant is lodged, family members, jailers, legal representatives, appropriate government. Okay. Why did you get confused with compounding and commute? This is mentioned, commentate. Not sure. Please read the questions carefully, guys. Always. Yes, it is jailer, and this is mentioned under section 420 that the warrant has to be lodged to the jailer and nobody else. This is only once. This jailer word is only once used in the whole CRPC, which is section 420. 374 of CRPC provides for a forum of appeal in which of the following cases: appeals to the session court, appeal against the order of conviction by the session judge, both 1 and 2, none of the above. No issues, Shaktija. Just read the questions. Everyone, this is an advice that read the questions twice. Always you will read between the lines. Yes, it is option number 3, and it is also a straight question from the Bear Act. No, it is both George High Court also and the Sessions Court also. Okay. Extension of period of limitation in certain cases is dealt under which of the following sections: 215, 420, 402, and 473. You can directly eliminate 420 because it talked about the warrant to be lodged to jailer. Is it 402, 473, or 215? Yes. It is 473. In certain cases, there is an extension given for the period of limitation, which is mentioned under 473. An under trial prisoner can be detained for a maximum of one-half of the maximum period of imprisonment specified, 1/4 of the maximum period of imprisonment specified, 1/3 of the maximum period of imprisonment specified, 2/3 of the maximum period of imprisonment specified. Come on, guys. This is an amended section and this should be known. Yes, it is 1/2. 1/4 udhar hai, in the provisions of fine in IPC. Not here. I think the section is 63. Yes. This is mentioned under section 436A, and this is an amended section. That what do you mean by an under trial prisoner? Can somebody tell me in the comment box? An under trial prisoner can be detained for the maximum of 1/2 of the maximum imprisonment, because otherwise there's been no use, right? He's an under trial prisoner. वो मैंने ही बता दिया. Under trial prisoner means the person who is going through the trial. If we keep him for the whole time period of his imprisonment, there's no use even of giving him punishment then. 1/2 is the maximum amount of imprisonment. So if a person is going to jail for 3 years, he cannot be kept during his trial for more than 1.5 years. Yes, accused, not convicted. Yes, the under trial prisoner. Correct. Unproved conviction. Yes, not convicted. Correct. Let's move ahead with the next question. Which among the following sections deals with direction of warrant for execution? 419, A 418, 479, or 219? Come on, I'm not going to show the screen now. This is a direct section based question. Yes, it is option number one, 419, which states that in which direction the warrant has to be executed. Yes. Which of these irregularities do not vitiate the proceedings? A tender of pardon under 306, to recall a case and try it himself under 410, to issue process under 187 for the apprehension of a person within his local jurisdiction who has committed an offense outside the limits of such jurisdiction, all of the above. Do not. There's no option 5, George. Yeah, 4. Okay. Yes. So everyone has answered correctly. All the mentioned cases, the proceedings will not be vitiated. Correct. Okay. Which of the following convictions is or are appealable? Conviction in petty cases by the court of the session with a sentence of 4 months imprisonment. Conviction by a high court in cases wherein the accused pleaded guilty, both 1 and 2, none of the above. Which of the following cases are appealable? See, this is the reason why I have put such question. Everyone is twisted now. Acha. George is answering 2. Now 4. Shaktija also 2. Guys, read it again. Conviction in petty cases by the court of session with a sentence of 4 months imprisonment. PT cases का section खोल के please check the amount of imprisonment where where you cannot appeal, where there will be no appeal. Yes, only one person answered it correctly. Shaktija, 2, 3, 4. Only one person. Manish answered it correctly. This is 1. Okay, so this is clearly mentioned that in a pity case, there'll be no appeal by the court of session with a sentence of 3 months imprisonment. And I asked, what is asked in the question is that which of the convictions are appealable? So 4 months hai, so that is appealable. Yes, Medha also answered it correctly. Only one first is appealable, where a person has pleaded guilty and the conviction was by the High Court. There will be no appeal. Appeal ka chapter, please read it again. Welcome, Nikunj. Yes, you answered it correctly. Okay. Under the Criminal Procedure Code, which factor is irrelevant for considering bail? Gravity of the offense, economic status of the informer or the victim, possibility of absconding the accused, all of the above. Okay. Let's see the correct answer. The correct answer is option number 4 here. See, considering the bail, the gravity of offense is not relevant because the provisions mentioned under, yes, correct, Anikwa. Provisions mentioned under CRPC has to be taken in consideration, not the gravity of offense. It is not on the discretion of the court. Schedule 1 has to be seen, whichever whatever is non-bailable, then the court has the discretion. Possibility of absconding the accused also is irrelevant. The correct answer is option number 4 here. That is why I kept the such questions in the uh, quiz today. If any attachment is made and the defect was found in the writ of attachment, the said attachment will be void, valid, illegal, none of the above. Starting में everyone was answering correct because starting में I kept very direct questions. Now everyone is taking their time and answering the questions slowly, gradually. Only Nikunja has answered. Guys, Jago. George has also answered. Shaktija has also answered. It is valid, not irregular. It is mentioned under 466 that whenever an error or defect is relating to attachment in the writ, in the summons, uh, and such a attachment is just because of the like the ऊपर ऊपर से defect जिसको बोल सकते हैं, the attachment will be valid, not void. Yes, it will be valid. Read section 4. Pura miscellaneous and pura, you guys need to revise whoever I'm finding the errors in. You guys need to revise the whole miscellaneous chapter and the whole wo bail wala sorry, the confirmation by the High Court of death sentence wala chapter and the appeal wala chapter. Again, which section of CRPC provides for translation of judgments of the court? This is, you guys have to answer. 278, 364, 413, none of these. Come on, guys. Yes. It is option number 2. Only Aniko answered it correctly and then answered it wrongly. This is section 364. Yes, Manish also answered it correctly. Which section of the CRPC may the court order a convict to pay costs? 280, 359, 299, 400. George also answered it correctly. Come on, answer this question now. Order a convict to pay costs. Yes, it is option number 2, which is section 359. Which section of CRPC establishes the direction of warrants for the execution of sentences of imprisonment? 419, 412, 421, 291. Okay. Yes, it is 419. Everyone is answering this correctly. Which section of CRPC deals with the amount and the reduction of amounts of bonds? 119, 419, 377, 440, 414. This, so you can answer very clearly. This is a kind of revision of your index. Reduction of bonds, the amount of bond. Yes. Manish was able to answer it correctly. It is 440, which mentions that the bond and the reduction thereof, how the court can reduce the amount of the bond. As per CRPC, sureties can make declarations of which of the following before the court: their assets, their own outstanding debts, the number of persons they have stood surety to, including the accused. Surety can make declarations of which of the following? Straight away from the Bare Act, but confusing a little. You will have to read between the lines. Okay, first time Aniko answered this incorrectly. This is Manish also answered. Why on the earth a surety has to make declaration of their assets? मेरे पास क्या है क्या नहीं है मैं क्यों बताऊंगी? If I'm going to, I have not committed a crime, I'm going to be a surety of a criminal, like criminal nahi but the accused. I'm going to be a surety of that person, right? Why I'm going to tell them क्या है मेरे पास और क्या नहीं है? I'm just going to tell them कि मैं कितने लोगों की पहले surety बन चुकी हूँ. Yes, Nikunj is able to answer it correctly. Medha also answered it correctly. Okay, read the bail का provisions पूरा 440 से लेके 448 तक, especially the bonds and the sureties वाले पूरा chapter. Section 430 of CRPC deals with which of the following? When bail may be taken in case of a non-bailable offence, power to commute sentence, power to suspend or remit sentences, return of warrant on execution of sentence. Okay. Let's see the correct answer. Yes, it is return of warrant on execution of sentence. The officer executing has to return the warrant to the court which it issued. Okay. When an offence is tried by the High Court otherwise than under dash, it shall, in the trial of the offence, observe the same procedure as the Court of Session would observe if it were trying the case. This is section 200 and 402, 403, 406, or 407. Come on, guys. थोड़ा सा ट्रिकी है, I know. Nobody. Nobody. This is 407. Please let me know, find out in the Barak. Let me know tomorrow in the IPC quiz. IPC quiz also I'm going to take tomorrow. Let me know which section mentions this sentence. Okay, let me know tomorrow. Okay, this is a homework. So let me know why this is 407 and why this is mentioned here. The compensation payable by the state government by way of victim compensation scheme shall be inclusive of payment of fine to the victim under section 326A, exclusive of payment of fine to the victim under section 326A, set off against the fine paid to the victim under section 326A cannot be determined. What is section 326A of IPC? Can somebody tell me? And the amendment year 326A and the amendment year. Am I audible, guys? Nobody is answering. Yes, it is asset attack. Amendment year 2013. Okay. The correct answer here is it is exclusive of the fine under section 326A. It does not include it. Reason behind that is it is such a grievous offense that the fine is not included. Yes. Okay. Which section of CRPC deals with condonation of delay? 473, 337, 229, or 387? Come on, guys. Yes, it is 473, which deals with condonation of delay. Okay. Section 482 of CRPC deals with which of the following? Duty of the High Court to exercise continuous superintendence over courts of judicial magistrates, repeals and savings, savings of inherent powers of High Court, none of the above. Hmm. Okay, this was really easy and really obvious. Can somebody tell me the correct section for duty of High Court to exercise continuous superintendence over courts of judicial magistrates? This is 482. Yes. Can somebody tell me this is I mean inherent powers? Can somebody tell me continuous superintendence wala section? Correct. It is 483. Okay. Who has the power to direct a reduction in the bail required by a police officer or magistrate? Is it a high court, court of sessions, either one or two, neither one or two? 484 is repeals and savings. 483 is continuous superintendence. Yes, it is option number three. It can be either the High Court or the Court of Session. An order to pay compensation under 357 can be passed in which of the following situations? When sentence of fine is only imposed, when sentence including a sentence of death of which fine forms a part is imposed, when sentence of which fine does not form part is imposed, all of the above. 357. Come on, guys. Yes, it is option number four. In all the situations, the fine under 350, the compensation under 357 can be passed, the order to pay compensation. Okay. Who is empowered under the CRPC to alter functions allocated to the executive magistrate, the government, the High Court, the state government after consultation with the High Court, either one or three? This is government. Okay. The correct answer is option number three. The state government, after the consultation with the High Court, can do it, otherwise, not. Okay. Only then the person can alter the function. Shaktija, please read everyone else. Hi, Dipankar, please read the miscellaneous wala part again. Anika also, Medha, very good. Only after the consultation of the High Court. See, this is the consultation when the state government has to consult, and then when the High Court has to consult. This is very common in the first few chapters of CRPC, also classes of courts, classes of criminal courts. There also, and this is also one of the sections where this minute detail is there. You have to remember this. Which section of CRPC deals with condonation of delay? This has been done. Section 482 deals with which of the following? Duty of the High Court to exercise continuous superintendence over courts of judicial magistrates. Just a second, guys. Just a second. Yes. Am I audible now? Okay. I hope the screen is also visible. Sorry, the computer, the laptop hanged. That is why the slides got merged. Which of the following authorities has the power to appoint the place of imprisonment? Is it a sessions court, state government, Appropriate government or the central government? What's the score, guys? The World Cup seems destined for. Yes, I know. I started the quiz when it was around 2 wickets. Yes, it is the state government, and it is mentioned under 417 that the state government has the power to appoint the place of imprisonment. When a metropolitan magistrate passes a sentence of imprisonment of 3 months, the appeal shall lie before the Court of Sessions, the High Court, both A and B, none of these. Come on. When a metropolitan magistrate passes a sentence of imprisonment of 3 months, none of these. Okay. Yes, it is none of these. There'll be no appeal in the given case because the mentioned time is 3 months, and I told you the time period of 3 months comes under the petty cases, and there'll be no appeal in such cases. So this is also where you get twisted, and only Manish and Nikunj, yes, are able to answer it correctly. Medha also answered it correctly. Pity case, yes. Cancellation of bond and bail bond is dealt under which section? 446A, 446, 441A, or 441? Come on, guys. A very basic straightaway question from the Bear Act. Yes, it is option number one. Very good, Medha Anikwa. It is 446A. Subject to the power conferred by which article of the Constitution, the forms set forth in the second schedule, with variations as the circumstances of each case require, may be used for the respective purposes therein mentioned, and if used, shall be sufficient. This is under which article? Article 110, 124, 220, or 227? This is a constitution question, guys. In between CRPC, coming like an arrow. Okay, so guys, you guys are able to answer it correctly. Yes, it is Article 227. When the very good George, Medha and Anikwa, when the person required by any court or officer to execute a bond is a dash, such court or officer may accept in lieu thereof a bond executed by a surety or sureties only. Lunatic, minor, widow, all of the above. Come on, guys, this is a really easy question. Yes. Yes, correct, Aniko and George. It is option number four, all of the above. The court or the officer may accept in lieu thereof a bond executed by a surety or sureties only when such person is lunatic minor or a widow, any of the above. As soon as the judgment or final order disposing of a case is signed, court may alter the sentence, review the judgment, correct a clerical error, may begin retrial of the case. Come on, guys. Yes. It is under section 362, which prescribes that it can review or alter and correct a clerical or an arithmetic error also. Uh, Final order disposing of a case is signed. Whenever the order is signed, the court may not alter the sentence or review the judgment or begin the retrial of a case in any case. So it may correct the clerical error only. What is the time limit of section 468 of CRPC for taking cognizance in case of a defamation? 6 months, 1 year, 3 years, no limit. Come on, guys. If you remember the punishment of defamation, you'll be able to answer this. This is about a criminal defamation. Difference of opinions here. Yes, the correct answer is option number three. It is 2 years, so that is the reason the time limit is 3 years and not 6 months. Shaktija, it is 2 years. The punishment for defamation is 2 years. छोटा मोटा offense नहीं है defamation. Appeal in case of acquittal by a magistrate may lie in the High Court, the Sessions Court, the Chief Judicial Magistrate Court, and or the no appeal lies. Come on, guys. Appeal in cases of acquittal. Okay. Dipankar has answered four, Shaktija has answered three, and Aniko was able to answer it. It is two. The appeal lies to the Sessions Court, guys. Appeal in case of acquittal by a magistrate, it lies to a session court. 378, guys, please read the whole chapter of appeal and the miscellaneous chapter. Again, especially Shaktija, George, and George was able to answer it correctly. Shaktija and I think Dipankar answered it wrongly. So please read the whole chapter of appeal again. Order for disposal of property at conclusion of trial by a criminal court. What is not correct? By destruction, by confiscation, delivery to any person claiming to be possession, claiming for possession, and by declaration of title of any person to the ownership of property. Come on. Not correct. This is also one of the important topics, disposal of property in the second part of CRPC. Let's see the correct answer. It is option number four. It is option number four. The court can only declare the title of the person to the ownership of the property and not the possession. Possession is relevant, very relevant in civil subjects and civil acts, but not in the criminal code. So, which is not correct. It cannot do the ownership wala thing. Otherwise, everything is correct. Yes, Shaktija was able to answer it correctly. It is 452. Who may complain for bigamy under Section 494 IPC? Mother, father, brother, or sister on behalf of wife? Police, any social institute, none of the above. Who may complain regarding the bigamy? Yes, that is the reason, George. The limitation was 3 years. Please read the sentence you have commented and read the punishment and then apply the logic. You'll be able to get the answer. Yes, it is mother, father, sister on behalf of the wife. Anyone can complain for bigamy, not any social institute, not any other person, only the mother, father, brother, or the sister on the behalf of a wife. The judgment of acquittal passed by a judicial magistrate is appealable before Sessions Court in any dash offence. Cognizable and non-bailable, cognizable and compoundable, non-cognizable and non-bailable, non-cognizable and bailable. Come on, guys. जीत गई क्या इंडिया? People are bursting the crackers. Yes, it is one. It is one, yes. 378 is the relevant section here, which provides the acquittal wala cheese and the offense has to be cognizable and non-bailable. Okay. Let's move ahead. Victim means and includes a person who has suffered any loss or injury caused by the reason of the act or omission for which the accused person has been charged, his or her guardian, his or her legal hire, or all of these. Section batao section. Which section defines victim under CRPC? I have kept this question because victim was one of the important points under victim compensation scheme and 372 as well. इसलिए मैंने ये डेफिनेशन रखी है यहाँ. WA. Yes, very good, very good. No, Medha, it is WA. Manish, yes, it is option number 4. Correct. Let's move ahead with the next question. 428 CRPC provides for concession to the effect that period of retention undergone by the accused be set off. Again, substantive period of imprisonment awarded against the period of imprisonment in default of payment of fine. A and B above, both are A and B, or none of the above. Guys, jeet gayi kya India? People are bursting the crackers here. I don't know whether you can hear it or not. 428 provides for concession to the effect that period of detention undergone by the accused to be set off. Is it the fine included or not? That is the question. Guys, the correct answer is 1 here. This is little twisted. The period of detention cannot be set off in case of fine. Please read section 428 again. It is only option number 1 against only substantive period of imprisonment. So this is also twisted a little, not for the payment of fine. Okay. Let's move ahead now. 439 of CRPC. Okay, no problem, Medha. Let's move ahead with the quiz. Just stay with me here for a few more minutes and for a few more questions. We are towards the end of the quiz only. Under section 439 of CRPC, the jurisdiction to cancel the bail vests with the Court of Session, the High Court, the Court of Magistrate, only A and B. Welcome, Jennifer. Yes, the correct answer is 2. Yes, the correct section was 2WA. Very good. Can someone tell me the amendment of 2WA? Yes, it is option number 4, both A and B. Now tell me which is the amendment act of 2WA. Can somebody tell me? Yes, it is 2009. Correct. When the High Court or any sessions judge calls for to examine the record of any proceedings before any inferior criminal court, it is known as review, revision, reference, none of the above. It is 2009, Shaktija. The victim compensation wala pura chapter and the victim word in 2WA. When the High Court or the Sessions Judge calls for to examine the record of any proceedings before any inferior criminal court, it is known as revision, review, or reference. Reference to chalo, let's eliminate it. It is review or revision. It is revision, guys. Yes. Inferior court की बात आ जाती है. So this is always revision. Review is by the same court. Okay, let's move ahead. In one trial, X is convicted against which no appeal lies, whereas conviction against Y is appealable. Whether X can file an appeal against this conviction or not. Yes, no, only with special leave, there is no such provisions. He can file an appeal. Let's check. Yes, it is section 380, which gives such right to X, not X, but a person who is convicted and no appeal lies, and the conviction against Y is appealable, then he can file against his conviction. Yes, it is correct. All of you are correct here. As per the provisions of the CRPC amended in 2005, a surety has to declare the number of accused for whom he is surety under which section? 440, 441A, 144, none of the above. This was dealt before also. So you guys can answer this, I think. This is an amended section in 2005, so always remember it. Let's check whether Medha is answering it right or not, or Anikwa. Yes, it is 441A. Always remember the amendment numbers and the amended sections. Yes, it is 441A. As per the provisions of Section 437 of CRPC, the jurisdiction to cancel the bail vests with the magistrate competent to try and entertain the offence, the magistrate where the magistrate has not ordered the release of on bail, the magistrate only where the magistrate has ordered the release on bail. None of the above. 437. Who has the right to cancel the bail? Okay, let's see. The correct answer is Anikwa Shaktija Nikunj here. The magistrate only where the magistrate has ordered release on bail. Please read the cancellation of bail wala section again. This is important. Actually, bail appeal and the High Court confirming the sentences. These three sections, including the limitation and the irregularities which vitiates the proceedings, are important for prelims. So read this again. While exercising its inherent powers under Section 482, the Code of Criminal Procedure, the High Court cannot review its own judgment, do all the mentioned things, convert itself into court of appeal when the legislature has not conferred a right to appeal to it, grant police custody from judicial custody. What he cannot do during the exercising of inherent powers. Come on, guys. He can, using the inherent power, he can grant police custody from judicial custody. Is it not mentioned like why the inherent powers are required even to convert police custody to judicial custody? Okay, let's check then. This is the last question, by the way, guys. Let's check then. Yes, it is Medha who has been able to answer. You can, like, all these things are already mentioned in CRPC. Why inherent powers are required to, do it even. Inherent powers are to do some things which are not there in the code. So it is option number 2. Okay, one more question. In case tried by a court of session or a CJM, the court or such magistrate, as the case may be, shall forward a copy of its finding or sentence, if any, to the superintendent of police in the area of whom the crime concerned was committed, the police station that conducted the investigation of the crime concerned, the High Court to which the trial court is subordinate, the district magistrate within whose local jurisdiction the trial is held. To whom they have to forward the finding. Okay. Let's check. Yes, it is answer number option number 4. This is directly mentioned under section 365. The court of session has to send copy of finding to the district magistrate. So they are indirectly connected. This is how the separation of powers in the country works. So this is all for today. We have covered 100 questions, guys. How are you feeling about the session? Come on, tell me. How are you guys feeling about the session? It's good. Very interesting. Thank you, George. Thank you, Dipankar. Shaktija, I hope you have learned. And Medha also, Anika also. Great. Okay. Let's catch up tomorrow for the IPC session then. At the same time, 7 p.m. Please encourage your friends also to attend these sessions because these will be fruitful. whoever is applying for the exam and whoever are not applying for the exam, please go and enjoy the match and let me also enjoy the match. We'll see you tomorrow at the same time with the uh, IPC quiz, which is going to be for the first part of IPC. Yes, correct, Shaktija. Okay, so let's catch up tomorrow, guys. Okay, chalo, signing off. Thank you so much for staying with me and answering the questions. Thank you.